Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. I hope your preparation for all the upcoming exams is going on well, and if you are facing any kind of trouble, you can check out our courses. You can visit our website iexamb.com or you can reach out to us on this number. We are discussing important legal maxims and today we have reached to part 4. We have already discussed 15 legal maxims. You can go back and revise them. Coming to the part 4, in our set 4, the first legal maxim is non-obstante. This means notwithstanding. A non-obstante clause is now a standard technique in legislative drafting. It is usually a legal device seeking to confer overriding effect upon a particular provision other than the conflicting provisions. Therefore, that particular provision will take precedence over any conflicting provisions. Coming to the next legal maxim, volenti non fit injuria. You must have heard this many times in tort law. This means injury is not caused to the one consenting to it. Injury is not done to a person who voluntarily agrees to that activity, and if any damage is done based on that consenting act, then there is no legal injury. In the law of torts, there is a duty on every person to do acts with reasonable care in order to avoid any harm which may occur due to their failure of taking such care. Now here, if a person gives his consent to doing of an act which leads to him getting injured, then even if the injury is caused by other person, he cannot claim damages from that person because the act was one for which he has voluntarily consented. For example, if A has a bike whose brakes are not working and B, knowingly about the conditions of the bike, still chooses to sit on it while A is driving it, and due to the failure of such brakes, they both sustain injuries in the accident. B cannot claim relief from A because he had voluntarily consented to sit on the bike. Similarly, if two boxers are fighting in the boxing ring, they have consented to getting hurt in the boxing match. So if one person is injured in the boxing match, he cannot claim damages from the other boxer. Let's move to the next maxim. Bona fide mala fide. You must have heard this many times. Bona fide means in good faith, mala fide means bad faith. The next maxim is actionis legis. This means lawsuits, legal action. It is also known as action at law. For example, if someone wants to sue another person, they would have to use a specific set of words and follow a certain procedure in court. This is what is known as legis actio, lawsuits, action by law. The next legal maxim is actori incumbit onus probandi. So you must have heard the term onus probandi, on whom the burden of proof lies. So here the meaning of this maxim is the burden of proof lies on the plaintiff. This is a rule of law that the burden of proof rests with the plaintiff or the prosecution, who must substantiate their case to secure a favorable outcome against the defendant. The next maxim is per incuriam. Per incuriam means through lack of care. It is also used in judicial precedent. If you remember, we have discussed two legal maxims related to judicial precedent. One was obiter dicta and another was ratio decidendi. Now coming to this per incuriam maxim, the doctrine of per incuriam refers to a judgment of court which has been decided without reference to or in ignorance of a statute or an earlier judgment precedent which would have been relevant and therefore affected the result of the case. Therefore, a finding of per incuriam means that a previous court judgment has failed to pay attention to relevant statutory provisions or precedents. Now there is also another similar legal maxim called sub silento. Per incuriam is a judgment which is passed in clear violation of legislation, rule or judgment, while sub silento is essentially the one passed without consideration or without discussion, which is passed silently. The significance is that if a judgment has been decided per incuriam, then it need not be followed by the lower court. So these were all the legal maxims in the part 4. I have discussed one legal maxim which is not mentioned here along with per incuriam sub silento. So remember these maxims, revise all the 4 parts that have been discussed so far. If you are facing any trouble in any part of your preparation for SEBI legal or any other upcoming exam, you can check out our various courses for every law officer exam. You can get yourself enrolled. You can check out our mock test, our study material. If you are looking for guidance, you can also reach out to us on this number which is mentioned on the screen. Enroll with iExamB and make your preparation 50% faster. Subscribe to our channel. Stay tuned. Thank you.